Criminal law is our next topic, but we're going to talk about it through the lens of business crimes. We're not going to talk about crimes like murder or rape and things of that nature. We're going to focus on criminal laws that relate to business or that occur in business. And criminal law, basically, is the conduct outlawed by society. And as I said, under the American legal system conversation, criminal law is founded in statutory law. It's created by legislative bodies. And it's the government who is the prosecutor. The government will bring the case against the party that they believe has committed a crime. If someone's found guilty of a crime, there'll be criminal penalties or sanctions that are imposed. They're designed to punish those who commit crimes and to deter others from committing similar acts in the future. So there's really two goals behind it. One is to deter others. If we're bringing cases and prosecuting for certain kinds of cases, people are seeing that, it prevents them or hopefully deters anyone else from committing that kind of crime. And then the hope is the punishment on the individual or entity who has committed the crime would deter them from committing similar acts in the future. Just a refresher from our discussion under the American justice system. Again, crime is a wrong against society. The punishment can be anywhere from a fine to imprisonment to even capital punishment or death. It's the government who brings the case, and their burden to prove a criminal case against an individual or entity is beyond a reasonable doubt. That is very important. The person or the accused does not have to prove anything. It's all on the government. And the goal is to punish those who commit the crime and to deter others from committing crimes. Let's take this example. Capital Bank customers receive emails telling them to click on a quote-unquote secured link. On the link site, they're asked to enter personal information to complete the installation of a new online security certificate. The site is a fraud, however. When unsuspecting customers click on the link, their computers are infected by programs that funnel personal data to the server. The stolen data then are sold. And the question is this a crime? Yes, we actually have a couple crimes here. It could be identity theft, and it could be something called phishing. This is collecting information and data either to use or to sell. And this is an example of a federal crime. It's the use of the internet. It spans across states or countries, so the federal government is prosecuting this kind of crime. It's this kind of crime, this particular crime, is one that is committed outside of business. But you can have crimes that are committed by businesses themselves or by the people running or owning the businesses. As I answer this question, can you have crimes committed by businesses or that are run by the people or both? And the answer is yes. Corporations can be convicted of crimes. Are they the actual ones committing the crime, this entity of a corporation? No, it's the people that run them. But in the end, it's not only the people who can be convicted of the crimes, but the corporation as well. For example, an example of a crime committed by somebody within a business or a corporation. Well, a typical one that we hear about often, an account manager, office manager skimming funds from the business account. We call that embezzlement. You guys maybe remember, heard the story about Enron. Several of Enron's executives were charged with conspiracy, insider trading, securities fraud. Enron's founder and former CEO, Kenneth Lay, he was convicted of 6 counts of fraud and conspiracy and 4 counts of bank fraud. The corporation itself had some liabilities. So the question, can corporations be convicted of a crime? Yes. We call that corporate liability. Under the law, corporations, under American law, corporations are considered or looked at as an actual person. They look like they're their own legal entity, just like people are. At common law, there was no corporate liability. Why? As we remember, common law stems back from Old English law. The reason why is under common law, or in England, corporations and businesses were owned by the government. In America, they are privately owned. So we recognize corporations as legal entities, and they can be held criminally responsible for crimes they commit. Do they go to jail? corporations, no, they can't go to jail. They're an entity. But usually what happens is an extremely large fine. So is it the actual corporation committing crimes? No. Who commits the crimes? The people working for them. The CEO, the managers, agents. We'll talk about agencies, employees. They're acting on behalf of the corporation. And if you remember from the example under the American justice system discussion, I talked about the Volkswagen case, how everyone, including the company, were convicted of crimes and they had to pay out. I just mentioned the Enron case. Corporations, they're held liable for the conduct of their employees by this doctrine that we call vicarious liability. This is where we're transferring criminal responsibility for an offense from the agent or the employee of the corporation to the corporation. And in this instance, in the two examples that I've given, the Volkswagen case and the Enron case, it's based on the employment relationship. The question becomes, is the agent and the employer responsible? Yes. The agent can be responsible as well as the business or corporation. But then we have some instances where the agent or the employee acts and the full liability is taken by the corporation. Let's take this example. Harry, who's an employee of Burger King, he shreds corporate documents in his office that could be deemed evidence when Burger King is sued civilly for sexual harassment in a multi-million-dollar case. Harry's charged with a crime. Can he be charged? Absolutely. Maybe something like destroying evidence or obstruction of justice. Can Burger King itself be liable? Yes, under the theory of vicariously liable. They don't need to know that Harry's doing that because what Harry's doing is for the benefit of the corporation. So in this instance, Burger King can also be responsible under that doctrine of vicariously liable. How about this example? Brad's the president and CEO of ABC Corp. He's texting on his cell phone driving home from work, and he recklessly hits and kills a pedestrian as he's driving home from work because he's texting. Can ABC Corp be held vicariously liable for criminal homicide? And the answer is no. The answer is no. Why do you think the answer is no? You might be saying because he's driving home, and you'd be correct. What if he's driving to meet clients during the workday and this occurs, the same incident? Can ABC be held liable, vicariously liable for criminal homicide, meaning a criminal charge? And the question that's going to turn on whether or not ABC knows that the president texts and drives while he's going between meeting and meeting, if there's some sort of knowledge to get to that level of being charged with criminal homicide. On the flip side of that, if they don't know, the answer could still be yes, but not to criminal homicide. This is something that we're going to talk about again under torts, and we're going to talk again under corporation liability when we talk about business structures, because the key component to corporate liability is that an agent or employee must commit the crime during or within the scope of employment. So if Brad is actually going from client to client and he's doing that sort of conduct, regardless of the knowledge, whether there's some further knowledge that's known by CEOs or other managers, because I have Brad as the CEO here, it's going to turn on whether or not there'll be criminal liability, which is a higher threshold than when there's tort liability, which is a lower threshold. And I'll revisit this again when we talk about torts in corporations. But the key point here for corporate liability to stick is the agent of the employee must commit the crime during or within the scope of employment. I want to address a couple more examples regarding this vicarious liability for businesses and corporations. Think of a store clerk who sells alcohol to a minor or sells cigarettes to a minor. Who's going to be on the hook for that? Not the store clerk. That would be strictly the business. So vicarious liability stretches to not just the employee-employer relationship. Even though a store clerk is working for a business, there might be some tie that we call a special relationship. But it can transfer, the idea is that it transfers defendant's liability, i.e. the store clerk who sold alcohol to a minor, to a different defendant who, in the store clerk example, is the employer. The employer just needs to be involved with the actor. And in this case, it's the store clerk. And in that instance, the business could lose their license to sell alcohol and be fined. Not the store clerk. The store clerk will probably be fired, right, by the business. So another example, I don't know if you guys remember Napster. This is going back a couple, maybe 2-3 decades at this point. But Napster provided a product that allowed peer-to-peer file sharing through the internet, and this was a big deal. Most of the users were using it to swap copyrighted music files and materials unlawfully. So the users were committing copyright infringement. Napster just provided the platform. They weren't the ones that were actually committing the crime of infringement. And that was their argument in the case when I think it was Sony Music that started the lawsuit against Napster, and criminal charges were brought against the corporate owner of Napster, and in the end, Napster was found vicariously liable based on a special relationship. Those people didn't work for Napster. They were using Napster's product, and they were using it in a way that was illegal, and Napster kind of turned their head. They're like, you can use it for legal things too. But most of what that platform was being used for was copyright infringement. Classifications of crimes. You may have heard these terms before. Misdemeanors, felonies, violations. Violations or infractions are not technically considered crimes. They are just punishable by a fine. Traffic infractions usually fall under this idea. There's noise violations, and there's a few other ordinances are considered violations. Misdemeanors and felonies are criminal in nature, meaning you end up with a criminal conviction at the end of that if found guilty. Misdemeanor is a lesser offense than a felony. A misdemeanor's maximum punishment is a year in the local jail. There's some other smaller things that can occur as punishments of a misdemeanor, but that's the maximum. For felonies, maximum punishment, depending on which state you are in, it could ultimately be death. But in the business world concept, it's usually some time in prison. The maximum time in prison anyone can be sentenced to is life without the opportunity of parole. Those are generally for those street crimes like murder. But there are business people who've ended up in prison. So what constitutes criminal liability? Well, every crime has at least two elements. There has to be an act. There has to be intent. I put number 3. They have to happen together. You have to actually act and with intent at the same time. That you have to have those together. But the two primary elements are criminal act and criminal intent. And sometimes a crime will require 2 more elements, causation and harm. But every crime has an act and an intent, some sort of, they call it mens rea, or state of mind is another way to look at it. So not all crimes require bad result. However, if a crime does require a bad result, we're going to see causation and harm. Let me give you 2 examples to flesh this out. It is a crime to place a prohibited pollutant or contaminant into navigable waters within the United States. So basically somebody has to, that the act is placing a prohibited pollutant into navigable waters of the United States. There has to be some state of mind. They're doing that intentionally or they're doing that knowingly. Prosecutor does not have to prove that the pollutant harmed anyone or anything, just that the defendant placed that pollutant into the water. So we got an act, we got a state of mind. State of mind is doing that knowingly or intentionally. This other example It is a crime to place prohibited pollutant into navigable waters within the United States and thereby causing death or serious bodily injury. So now we're one step ahead. So just putting a pollutant into the water isn't going to do it in this example. You actually have to cause somebody's death or serious bodily injury. That's the cause and the harm component if a statute requires it, if a law requires it. So let's just break these up a little bit. A criminal act, criminal intent. So criminal act, actus reus is the fancy term, a voluntary, unlawful bodily movement. The statute itself will say what the act is, and in some case, a failure to act or an omission can be an act for purposes of breaking the law, but the act has to be voluntary. If somebody breaks into a business and they've been sleepwalking, we're not talking about a voluntary act there. And actually, most penal codes or criminal codes will name things that are not criminal acts. A non-criminal act is bodily movements, not the product or effort of the actor. So somebody who has convulsions, has blacked out or hypnotized, there's a number of different claims that people can make relative to that. But it has to be an act, the product or effort of the actor. So that's the key component. Let's talk about omission or failure to act. In only a handful of states do we have Good Samaritan laws, folks who are required to do certain things. I do not want you to confuse this with the idea that medical professionals have to stop at an accident, let's say, for example, and help out. They cannot be charged criminally. That the whole idea of that Good Samaritan is something we will talk about under tort law. What that does, the Good Samaritan, is it hopes that people who have medical backgrounds will stop when people are injured, or they come up on a car accident, or they see somebody hurt and they help them. The hope is as an incentive to help them. And because of their help, they cannot be sued for some, if they did something wrong in that moment. That's the Good Samaritan there. What I'm talking about here is you see somebody who needs help. They're getting beat up. Somebody's in danger, and you just ignore it. You don't call 911. You don't try to intervene. Our country does not require us to, well, I should say most states do not require us to act. We have no duty to act. There are only 4 states that do that, and actually one of the states is Vermont. They actually require people to call 911 if you see somebody in need of assistance. But under certain laws, if there is a duty that exists and you don't take action to assist, then you can be arrested for a crime. So a statute will have to say that. It's made in a contract, or there's some sort of special relationship. So let me tell you about those, some examples of these. And these vary from state to state, but these are primarily the 3. So a statute, a failure to pay taxes. If you don't pay taxes, then you can be arrested of a crime. There's a statute, because I said this is a failure to act, and so if you fail to pay taxes. Some folks are mandatory reporters for child abuse, like teachers. And if a teacher suspects that there's child abuse and they do not report it, they can be arrested for a crime. Contract, doctors helping a patient, their patient or client, not everybody. Lifeguard, somebody's hired to be a lifeguard and you don't save people who are drowning in your zone. That's something that's under contract. A special relationship, parent-child, spouse to spouse, and in some instances an employer or employee. And the question becomes why? Because there's some level of dependence on some individuals to another. What if you put that person in danger? Well, you may have a duty to rescue if you're the one that created the situation. Parents can be criminally charged for, neglecting their children. People in nursing homes have a duty to care for their residents. Correction officers have a duty to inmates. If you start to provide aid when you don't have a duty, you may be required to continue or to offer some sort of aid, or potentially there could be some criminal liability. The second element required in a statute, criminal intent. With few exceptions, this is an essential element, just like the act. The actor has to act with some sort of mental state. Most statutes will provide the necessary state of mind that must be proven. Some examples: intentionally, willfully, purposefully, knowingly, recklessly, negligently. Somebody acts with these states of mind, and we have different levels, states of mind, because it determines level of culpability, meaning accountability or responsibility for that particular fault or wrong. Think of it as if somebody behaves in an intentional way, somebody intentionally puts a pollutant in the water, in the navigable water, they do that intentionally, that is going to have a higher punishment, a higher level of culpability than someone who does that negligently. They don't do it on purpose. They don't do it with intent. They don't know that they're doing it. There's some corporations where things just kind of do a runoff and it ends up in lakes miles away. The way it travels across, the land and the dirt, or underwater or underground, they don't realize that. So there's different levels, and people can act intentionally, they can act with knowledge, they can act recklessly, and negligently. So higher up on the chain is intentionally, the highest level of culpability. Recklessness maybe is kind of somewhere in the middle, and then negligently is the lowest component of culpability. So depending on the level of culpability when somebody acts is what is going to determine how harsh of a penalty they end up with in the end. And my last component here, exceptions to this intent. Remember I said there's a few exceptions. This is where defendant's state of mind of intent is not necessary to be proven. And I've already said that with vicarious liability. It's hard. I just said the store clerk sells alcohol to a minor. The business didn't do anything. It was the store clerk. They acted intentionally, negligently, in some form, but the person that ended up responsible was the business or the entity. So vicarious liability, you don't need to show a state of mind on the part of the business or the corporation where liability is transferring to. So that's one component. We've talked about vicarious liability. And the other is strict liability. Behavior is criminal when the defendant commits an act regardless of what his or her intent or mental state was when committing the action. Again, failure to pay taxes, it doesn't matter whether you've done that intentionally, negligently, recklessly, still that is a strict liability crime. Speeding most traffic infractions are strict liability crimes. The police or the prosecutor doesn't have to show you intended to speed. Just by the very fact of speeding, it's a strict liability. Oil spills generally fall in this category of strict liability. And the question is why? Why do we have this type of liability? Because it protects these things where we have strict liability laws for the purpose of protecting public safety. So for the purpose of protecting public safety. So that ends this slides. Next up, we are going to discuss the constitutional protections that the person accused or the entity accused of a crime has.